Good afternoon and welcome to the first Taylor Wessing Contentious Trust and Estate webinar, during which we will discuss the practical issues for trustees to consider when a dispute arises. By way of introduction, my name is Kate Silverman and I'm a Senior Associate in the Contentious Trust and Estates team. My co-presenter today is Rob Gibson, another associate in our team. Before we move on to the substance of the presentation, we thought it would be helpful to give you a brief overview of the Contentious Trust and Estate team here at Taylor Wessing. As you'll see from the slide, the team is headed up by Emma Jordan and comprises of two other partners, Andrew Hine, who is head of our private client group, and Kirsty McGeown, together with 5 associates. We have a very broad client base, which includes private trust companies, individual trustees, high net worth beneficiaries, settlors, and protectors, so we're well placed to see disputes from all angles. We will have an opportunity to address any questions at the end of the presentation, so please feel free to submit any questions you may have at any time during the talk by typing them into the box at the bottom of your screens, and we'll endeavour to deal with as many as we can at the end. So turning first to why disputes arise. As you're probably all very aware, the causes or triggers of disputes in relation to a trust are boundless, but we find that they typically include one of the following scenarios: either the insolvency, mental incapacity, death or divorce of a settlor. Alternatively, the family breakdown, typically as a consequence of remarriage or death. Alternatively, a breakdown in the relationship with the trustees or advisors to the trust, or some other communication difficulties. By way of example, we're currently acting for trustees who are being sued for breach of trust by one of the beneficiaries on the basis that she alleges that the trustees favoured other beneficiaries over her and they did not give proper consideration to her situation when the trustees made distributions from the trust. And her relationship with the trustees, and in fact with the other beneficiaries, has broken down over a number of years, and that has led to the rather acrimonious dispute with which we're now dealing. Another common trigger for litigation is where a trustee makes mistakes in the administration of a trust, or the trust has a poor investment performance. We also come across ownership claims from third parties to assets put into the trust. We currently have a case where there are marital difficulties between a husband and wife, and the husband has tried to settle assets, in our case in company shares, which belong to his wife, into a trust, to essentially put them outside of her reach. Finally, we also see disputes with tax authorities seeking to enforce liabilities against the assets in the trust.
I am sure you're all aware of the types of claims we see in relation to trusts, so just by way of a very high-level summary for you, you will see from the slide that I'm now going to quickly run through a few of the disputes we are currently seeing. The most common claims are for breach of trust. These arise from the exercise by the trustees of their powers, in particular in the case of discretionary trusts, or when administrative and investment powers are exercised. We also commonly see allegations that a trust is a sham, although actual claims are less common. As you are no doubt aware, a claim of sham is effectively a claim that the trust is not a proper one and is essentially a pretense. If a court finds that a trust is a sham trust, it will determine the structure to be void. However, it is rare for a sham claim to actually succeed, as it is a very difficult case to prove. Case law has held that in order to succeed with such a claim, it is necessary for all parties, namely the trustees and settlor, to have a common intention that the acts or documents do not create the legal rights and obligations which they give the appearance of creating. As it's so hard to prove sham, we instead often see claims for what is known as piercing the corporate veil. This occurs when a court looks behind the company which holds the trust assets and assesses the actions and behaviour of the directors of that company. Obviously, a valid trust should contain the 3 certainties: intention, subject matter and object, and a well-drafted trust deed will make clear that all certainties are present. However, in terms of claims, the certainty of intention will often be challenged by an allegation that the settlor did not understand the nature of the act. Other common disputes include claims for lack of capacity or undue influence on the part of the settlor to establish the trust, or when he determines the class of beneficiaries. Finally, we also see a number of fraud and tracing claims, which often arise where a third party owns assets which have been settled into a trust, often to put the assets out of reach of others.
Just turning now to the issue of disclosure, as you will all no doubt be aware, once a dispute has actually commenced, one of the key procedural stages for trustees to consider is that of disclosure. I'm sure you've all had plenty of experience of the process of disclosure in one form or another, but I thought it would be helpful just to run through a brief recap of the basics before moving on to discuss some recent developments in this area. So disclosure is the process by which parties make available to the other side all documents which either support or undermine the respective party's case. The purpose is to allow the court to do justice between the parties with an all-cards-on-the-table approach. The question of whether a document should be disclosed will be determined by reference to the issues raised in the parties' respective statements of case. The obligation to disclose documents extends to those that are within a party's control. Now, control means any document in which a party has or has had physical possession, a right to possession, a right to inspect, or a right to take copies of the documents. Now, this will include documents in the possession of an employee or an agent over which the party has control. It may also, in certain circumstances, include documents held by subsidiary companies, professional agents, and ex-employees. The meaning of documents is not restricted to paper or to originals. It also includes electronically stored information, for example, emails, including deleted emails, and data held in databases. Electronically stored information also extends to anything upon which information of any description is recorded, so it will include electronic personal organisers, file servers, backup tapes, and hard drives. It can also extend to the metadata attached to each document, so this is the history of the document itself, such as the original author, the creation date, hidden notes, and blind copy recipients. Hard copy documents, as you might expect, will include correspondence, faxes, memorandums, reports, photographs, plans, diaries, or minutes. Relevant documents must be disclosed whether or not they're confidential. However, sensitive information, which has very little or no relevance to the actual dispute, but which is contained within a document that has to be disclosed, can be redacted. Now, each party is required to make a reasonable and proportionate search for documents. Determining what is reasonable and proportionate will be different in every case. However, it will generally include reviewing the nature, complexity, and the size of the case, the number of documents which may potentially be involved, the cost, and the ease of retrieval of those documents. From a practical perspective, as soon as a dispute arises, you should take steps to ensure that relevant documents are not destroyed or modified. So any routine policy for the destruction of documents, including in relation to electronically stored information, which may be relevant to the dispute, must be suspended, and any documents which may be potentially relevant to the case preserved. We suggest that at the outset of a potential dispute, you should gather and collate all hard copy documents that may possibly be relevant to the dispute and transfer them to a central safe location. Those documents should not be annotated, marked, or altered in any way, and documents within files should not be rearranged. If there's a large volume of electronically stored information, we suggest that you discuss with your lawyer the best method for it to be collected, searched, filtered, and reviewed in the most appropriate and proportionate way, and that will often involve some engagement with your IT department. It's important to bear in mind that the disclosure obligation continues until the conclusion of the proceedings. If relevant documents are identified or created after you've served your list of documents, they must be disclosed to the other side as soon as practicable. When considering disclosure, it's also really important to consider in what capacity you hold the documents. It may be that the same individual is both a trustee and a director of an underlying company within the structure, and the role in which documents are held will affect your disclosure decisions. The case law surrounding a beneficiary's access to company documents is still a developing one, and there's not actually a great deal of English case law dealing with this issue. But broadly, the position is that beneficiaries who wish to have sight of company documentation are to be treated as though they're shareholders of the company, and therefore, if they can make out a proper case for seeing such documentation, then the court, who will be acting in their supervisory capacity, should grant the beneficiary access to those documents, unless there's a valid objection from the directors. Now, disclosure is also often an issue prior to litigation actually being commenced, as parties may seek documentation in order to decide whether or not to pursue a claim. We often see cases where beneficiaries request certain trust documents from trustees prior to the litigation. Now, the question of whether beneficiaries are entitled to such documents will depend upon the law governing the trust in question. Under English law, beneficiaries are generally entitled to disclosure of documents belonging to the trust, and Part 31 of our Civil Procedure Rules can be used to try and obtain pre-action disclosure. Whereas in other jurisdictions, such as the Bahamas, the law is much more restrictive and disclosure of documents generally rests entirely at the discretion of the trustees. This more protectionist approach is causing disgruntled beneficiaries to look for alternative and increasingly creative ways to obtain trust documentation. Now, by way of example, we are currently acting for a professional Bahamian trustee who faces a claim brought by a beneficiary in the Bahamas. The beneficiary in question has sought to circumvent Section 83 of the Bahamian Trust Act, which essentially enables trustees to withhold documentation from beneficiaries by issuing a subject access request under the Data Protection Act here in England against this firm, who are long-standing legal advisors to the trustee. Now, this firm resisted the subject access request on various grounds, including that the personal data held by the firm is held only in connection with its capacity as the legal advisor to the trustee, and accordingly, it falls within the exemption under the Data Protection Act regarding an organisation's right to maintain their legal professional privilege. The claimants, however, issued a claim against the firm for breach of the Data Protection Act, as they argued that the legal professional privilege exemption did not apply in this case because under English law, the trustee could not maintain a claim to privilege as against one of its beneficiaries. The case was heard at first instance last year, and the judge in the case held that the Data Protection Act should be interpreted purposefully. And he stated that it's no part of its purpose to provide claimants with information or disclosure of documents which may assist them in litigation, whether it be in England or in the Bahamas. Moreover, the judge held that as the only possible proceedings, and in fact the actual proceedings in this case, are in the Bahamas, the relevant exemption section of the Data Protection Act should be interpreted as covering all the documents in respect of which a party would be entitled to resist compulsory disclosure in the Bahamian proceedings. So Taylor Wessing was successful at first instance, but the claimants have actually appealed this decision, and that appeal has been listed to be heard in mid-July this year. The Information Commissioner, interestingly, has also applied to join the appeal as an intervening party and make submissions on the issue before the court. Now, the outcome of the upcoming appeal may have a real fundamental effect on the trust industry and the manner in which trustees' legal advisors hold trust documentation going forward. And we will be providing an update on the outcome of that case in due course.
So still on the topic of disclosure, another alternative tool for beneficiaries seeking disclosure of documents is through what is known as Section 1782, an American statute that authorises a US District Court to order a person found or resident in the district to provide information or documents for use in a proceeding in a foreign or international tribunal. To invoke Section 1782, an applicant must satisfy three conditions. Firstly, the person from whom discovery is sought must reside or be found in the district of the court to which the application is made. The US courts have held that person includes legal entities and individuals, and that being found in a district is a lesser requirement than being resident in the district. This element of the test can therefore be satisfied even if the target of discovery is served with a subpoena whilst travelling through the district. Secondly, the request or application must be made by a foreign or international tribunal or upon the application of an interested person. Here, an interested person is a party to foreign litigation or a person with some right to submit evidence to a foreign court or tribunal. Thirdly, the evidence sought must be for use in a proceeding in a foreign or international tribunal. Evidence may be sought for use in a foreign proceeding whether or not the evidence would ultimately be admissible in a foreign court. It's not for the US court to consider the evidence's admissibility, nor does the court need to determine whether the requested evidence would be discoverable in the foreign proceeding. So this is a particular issue to which trustees need to consider, as they will not be able to rely on local law, which may prevent disclosure to beneficiaries and other third parties. Also, the concept of proceedings has been broadly interpreted and includes international tribunals with the district court increasingly also granting 1782 applications in aid of non-traditional, non-adjudicative proceedings, including investigating magistrates, administrative and investor state arbitral tribunals, and also quasi-legal, quasi-judicial agencies, as well as the more conventional civil, commercial, criminal and administrative courts. As regards to the stage of the proceedings, Section 1782 requires only that a proceeding be within reasonable contemplation. Proceedings therefore do not need to be pending, or imminent. There are a few ambiguities in respect of reliance on Section 1782, which I just want to touch upon now. At present, it appears unclear whether private arbitration falls under the scope of being for use in a proceeding in a foreign or international tribunal. Recent case law from the District Court of the Northern District of California noted that various courts had split over whether private contractual arbitration would qualify as a foreign or international tribunal. This court held that private arbitrations established by contract are categorically excluded from the term tribunals. However, due to conflicting court interpretation, we would not suggest ruling out an application under 1782 in international arbitration proceedings. Another question which remains unclear is whether Section 1782 empowers a district court to compel the discovery of documents located outside of the US. This issue has been the subject of conflicting decisions, but more recent case law from the Southern District of New York indicates that the courts are interpreting 1782 restrictively and limiting documents to those within the US. However, it's not only documents in a physical office which cause a risk for trustees of a 1782 application. If trustees have servers located in the US, all documents on that server could potentially have to be disclosed following a successful 1782 application. So to put this into a practical context, a situation may occur whereby a disgruntled beneficiary who has issued proceedings in a foreign jurisdiction organise themselves so that they're able to serve a subpoena on a trustee when they are either travelling through the United States or potentially on the office of a trust company in the US. There's then the possibility that the trustee will be obliged to disclose to the beneficiaries those documents which are held in the US, or even potentially documents outside of the US. In any event, Section 1782 is clearly an increasingly powerful tool for parties seeking to obtain documents in relation to either active or reasonably contemplated litigation, and it's a procedure which trust companies in particular need to be alive to.
Moving on now to the topic of privilege. As you'll be aware, privilege entitles a party to withhold documentation or evidence from production to a third party or to the court, and this evidence may either be written or oral. Now, there are two main types of privilege. Firstly, legal advice privilege, which arises in those confidential documents which pass between a client and their respective legal advisor, which have come into existence for the purpose of giving or receiving legal advice. Now, it's important to understand the distinction between confidential and privileged documents. Not all communications between a client and their lawyer are privileged, notwithstanding that they may be of a confidential nature. However, privilege will no longer apply if a document loses its confidentiality, so it's important to maintain confidentiality in all privileged documents. Secondly, you've got litigation privilege. Now, this arises in those communications passing between either the lawyer, obviously acting in their professional capacity, or the client, or a third party. The communication here must be made for the dominant purpose of litigation. The litigation must be pending, reasonably contemplated, or existing. In most, and arguably all cases, the communication must also be confidential. There are other types of privilege, and the most common one which we see arising in a trust dispute context is common interest privilege. Now, common interest privilege enables parties who share a common interest to exchange information in a confidential manner without waiving privilege which exists within those documents. Those parties are entitled to assert their common interest privilege in the communication against the rest of the world. Now, as trustees, you need to be alive to privilege issues when dealing with contentious matters, as it's easy to inadvertently waive privilege in a document or communication, and that may subsequently be very detrimental to your position in a dispute. So let's take a hypothetical scenario. Let's say we have a trustee of a discretionary trust who enters into a contract with an investment advisor. The investment advisor gives negligent investment advice. The trustee obtains counsel's opinion, paid for from the trust fund, on the merits of any claim against the investment advisor. The trustee subsequently does in fact issue a claim against the investment advisor for that negligent advice. A beneficiary of the trust then requests a copy of counsel's opinion, which the trustee voluntarily provides. The case against the investment advisor proceeds, and it reaches the stage of disclosure, whereupon the investment advisor requests the trustee to disclose the copy of counsel's advice which it has provided to the beneficiary. Now, in this scenario, is the trustee obliged to provide that copy of the advice to the investment advisor? In this situation, the disclosure of the advice to the beneficiary will not be protected by legal advice privilege, as it was not a communication between a lawyer and their client. It arguably would also not be covered by litigation privilege because the dominant purpose of providing the advice to the beneficiary was really acquiescing to their request rather than for the actual purpose of litigation. The disclosure may be protected by common interest privilege on the basis that both the trustee and the beneficiary share a common interest in bringing the claim. However, this is still very much a developing area of the law, and the investment advisor may challenge any attempt to resist disclosure on that basis. So in this situation, it would have been helpful for the trustee to have considered the issue of privilege prior to disclosing anything to the beneficiary. And if after considering the issue, they did still wish to disclose the document to the beneficiary, then they should really have done so by marking that communication as being subject to common interest privilege. Another privilege issue which we've recently encountered in a case relates to the privilege existing in communications made between a lawyer and trustees as a group. The question we considered was where there are multiple individual trustees who receive legal advice, can one trustee disclose that advice to a third party? The legal advice privilege which exists in a communication from a lawyer to the trustees as a group will belong to those trustees as a group, and a trustee should not therefore disclose any communication which would ordinarily be protected by legal advice privilege without the express approval of their fellow trustees. Another important privilege point to consider during litigation is the fact that the disclosure obligation, which I discussed earlier, is a continuing one, and it will apply to any new document that may be created even after disclosure lists have been exchanged. So the creation of any internal documents discussing the merits of the litigation should be created with real care. You need to consider what is said in any new document about the subject matter of the dispute, so for example within internal reports, board minutes and emails. Reports about the litigation and its merits should really be prepared by internal or external lawyers, or alternatively such reports should do no more than pass on or summarise legal advice, so as to ensure that they remain privileged from disclosure. Now, whether privilege in a document has been waived can be of real importance. If privilege is lost in respect to the document, the other party may only see that particular document, but if privilege is waived, that waiver may extend beyond that particular document. Now, there are various different forms of waiver. Express waiver is pretty self-explanatory, but you also have selective waiver. Now, this occurs where selective disclosure is made to a select group. In such a scenario, you would no longer be able to claim privilege against that group, but you could still exert privilege against anybody else. Similarly, limited waiver applies where privilege is waived for a limited purpose to a limited personal group. So, for example, showing a privileged document to a regulatory authority for the purpose of identifying a breach by a third party. You also have inadvertent waiver, which, as you can probably guess, occurs where privilege is unintentionally waived. Now, this has quite recently been considered by the Court of Appeal in the 2014 case of Rawlinson and Hunter trustees and the Director of the Serious Fraud Office. In this case, it was held that a receiving party owes no duty of care to the disclosing party, and it is entitled to assume privilege, which might otherwise have been claimed, has been waived. Where a party gives inspection of documents which include privileged documents by mistake, they will generally be unable to rely on privilege as a basis for correcting any such mistake. That said, in the absence of fraud or circumstances which make it unjust to grant relief to the disclosing party, a court may grant an injunction preventing the receiving party from reviewing those documents where disclosure is the result of an obvious mistake. Now, whether a mistake is obvious is assessed on whether a reasonable solicitor would consider a mistake had been made on receipt of those documents. So you'll appreciate there are a lot of privilege points which trustees do really need to be mindful of when disclosing trust-related documents to beneficiaries or to other third parties, particularly when litigation is reasonably contemplated. And we would advise that trustees should seek legal advice if they have any doubts before they share any communication to ensure that such disclosure will not affect their position going forward.
Okay, so now I'm going to discuss some alternative options to litigation for resolving disputes. It's obviously in all parties' interest to settle trust disputes without litigation. It will save all parties legal costs and also help them to maintain confidentiality, thus reducing the risk of unwelcome publicity. There are various forms of alternative dispute resolution, or ADR, which trustees should be aware of and consider if faced with a dispute. The most common form of ADR, which most courts require any parties in litigation to have at least attempted before proceeding with a claim, is mediation. Mediation is a process whereby parties, with the assistance of a neutral third party, the mediator, identify the issues in dispute, explore the options for resolution, and attempt to reach agreement. It's voluntary, non-binding, and a private form of dispute resolution, and it helps the parties retain control of the decision on whether or not to settle and on what terms to settle. Because of this, mediation allows for more creativity and flexibility over settlement options than you would get when litigating in court or arbitration. On the subject of arbitration, this is another form of ADR, and this is based on the parties agreeing to submit the dispute in question to arbitration. So arbitration takes the form of a private forum in which an independent arbitrator or arbitrators makes an award, acting in a judicial fashion to finalise the dispute. The arbitrator focuses on the issues, which can be issues of fact or law, presented by the parties, and then issues an award which is final and binding on those parties. The Arbitration Act 1996 governs arbitrations in England. Arbitration may either be ad hoc, where the parties determine whatever rules they may consider appropriate for the arbitration, or administered, where the arbitration is administered and supported by one of the several arbitral organisations, such as the International Chamber of Commerce, the International Centre for Dispute Resolution, or the London Court of International Arbitration. The primary advantage of arbitration is that matters are kept confidential between the parties. This is for obvious reasons especially important in the context of family settlements, particularly where the settlor or beneficiaries are keen to avoid details of their lives becoming public knowledge. Similarly, professional trustees may wish to avoid adverse publicity in respect of trust management and administration through media coverage, which often surrounds high-profile court proceedings. It's also often said that arbitration can be cheaper than litigation, although in recent times, in our experience, the cost of arbitration has increased significantly and the savings are not as large as they used to be. The trust lawyers have been considering for some time the effect of an arbitration clause in a trust deed, and specifically whether this can bind all the parties, including the beneficiaries. So with this in mind, I'm now going to briefly run through what's required for an arbitration clause to be valid in a trust deed and who that arbitration clause will be binding on. So for an arbitration clause to be valid, it must be worded as an agreement between the settlor and trustee, as opposed to merely an administrative provision or direction of the trust. You'll see on the slide that there's example wording, and just let you have a quick read of that. But one thing that you should be aware of within this clause is that it would also be advisable to have a wide definition of the term disputes within the trust deed, so that all disputes that you may want to be determined by arbitration are actually covered in that definition. So whilst this clause is likely to cover the relationship between settlor and trustee, one would also need to consider how disputes involving beneficiaries fits into an arbitration clause, as obviously beneficiaries are unlikely to be party to the actual trust instrument. So for this, we need to turn to statute, and in particular the Arbitration Act 1996, which I've already alluded to. In this Act, section 82.2 states that references in this part to a party to an arbitration agreement include any person claiming under or through a party to this agreement. So this wording would imply that, dependent on the wording of your actual arbitration clause being wide enough, a beneficiary would be bound by the clause, and they would be claiming through the trustee. Specific jurisdictions have enacted legislation as part of their trust law to specify the binding nature of arbitration provisions upon beneficiaries. So for instance, in Guernsey, section 63 of the Trust Guernsey Law 2007 deals specifically with settlement of actions against trustees by alternative dispute resolution. This states that any settlement is binding on all beneficiaries of the trust, whether or not yet ascertained or in existence, and whether or not they are minors or persons under legal disability. Singapore is another well-known trust jurisdiction that has enacted a provision allowing arbitration as part of its trust law. Jersey is currently considering its position as part of the consultation on their latest amendments to trust law. So in the absence of any legislation, what we need to do is we need to look at the case law surrounding the binding nature of an arbitration clause. And as you might expect, different courts have different views on the subject. By way of example, the Texas Supreme Court has recently held that an arbitration provision contained in a trust deed was enforceable against the trust beneficiaries. However, in the English Privy Council decision of Cocciani from 2014, the court disagreed with the argument that an exclusive jurisdiction clause ought to be binding on the beneficiaries. In this case, the court stated that while it is right to confirm that a trustee is entitled to insist on and enforce an exclusive jurisdiction clause in a trust deed, the weight to be given to the existence of the clause is less than where one contracting party is seeking to enforce a contractual exclusive jurisdiction clause against another contracting party. So this seems to suggest that under English law, an arbitration clause will bite as between settlor and trustee, but may not bind the beneficiaries. As I've already said, the key difference between jurisdictions is whether or not there is a statute which provides for the arbitration provision to bind beneficiaries to the trust. So if you are including an arbitration provision in the trust deed in order to bind the beneficiaries, you may wish to include some further wording, which I've also set out on the slide. Again, I won't take you through the whole thing, but I'll just leave it on there for you to have a quick read of it. One final point to consider about arbitration is that if the trustees wish to retain cost protection in relation to the arbitration proceedings, we would still advise that they go to the relevant court to obtain a better order for protection. Just because they're trying to resolve the dispute by way of arbitration rather than litigation doesn't mean that the supervisory jurisdiction of the court has been ousted. And for the purposes of protection in relation to costs, it would seem prudent to us to go to court rather than the arbitral tribunal. That leads me nicely on to the final thing that we're going to look at today, which is the issue of costs, and which is obviously a major concern for any trustee faced with a dispute. Whilst trustees are generally able to recover their costs incurred in the administration of the trust, the issuing or defending of litigation falls outside the ordinary administration, and therefore the costs incurred in relation to such litigation may not be recoverable from the trust. Cost of litigation can, as we know, be very substantial, so it's vital that trustees obtain cost protection as soon as possible. And therefore, we're just going to focus briefly on trustee applications for BEDO relief. The principal purpose in bringing a BEDO application is for the trustee to obtain court approval for steps taken or to be taken in litigation, and thus to obtain cost protection. Typically, a trustee brings a BEDO application when he is unable to obtain an indemnity from a beneficiary to pursue or defend a claim. So what will happen is a trustee will seek directions from the court as to whether to bring, defend, or continue proceedings by or against the trust. The basis of the application is that the costs of proper litigation are costs incurred in the administration of the trust, and therefore the trustee is normally indemnified, with the general rule being that a trustee is indemnified for expenses properly incurred by him in the course of carrying out his duty as a trustee. That comes from the case of Re-BEDO from 1893. So the trustee should pursue a BEDO application before incurring expense in bringing or defending a claim. Otherwise, the litigation is conducted at the trustee's own risk as to costs. The application is almost always issued by the trustee seeking BEDO protection. All of the trustees must be parties, so either as claimants or, if they refuse to be joined as claimants, as defendants. You'd also usually see some of the beneficiaries as parties to the application, as the court is keen to ensure that all potentially different interests and viewpoints are represented. The court reviews submissions from the trustees and beneficiaries and then decides whether it's in the interest of the beneficiaries as a whole for the underlying proceedings to be either commenced, defended, or continued. This is an exercise of discretion from the court. There are no restrictions on what the judge may consider relevant, but usually the judge will take into account the likely outcome of the underlying proceedings, the likely cost outcome, and the value of the proceedings to the trust.
That concludes the substantive part of our presentation, but we do have some time for some questions. We've received a few questions during the course of the presentation, so I'm just going to cherry pick a couple, and we will follow up with those questions which we don't have time to answer by email. So one of the first questions we've had in is as follows. Somebody's asked, for privilege to arise in a document, do you need to expressly mark it as privileged when you disclose it to a third party? The answer to this is that technically no, you don't. A document can still be protected by privilege even if it hasn't been marked as privileged on its face. But of course it's always helpful to do so, because should there be any dispute as to the context in which a document was disclosed, attaching a contemporaneous label to it will help from an evidential perspective. Another question that we've been sent through relates to arbitration. So Rob, do you want to deal with this one?
Yeah, sure. The question that we've had sent in is, if you settle a dispute by way of arbitration, can you appeal that decision, or is it a final decision? So basically, an award is equivalent to a judgment in litigation, and it is final and binding in that it provides a final determination of that dispute. But saying that, it can still be challenged in certain circumstances. So under English law, as is the case with court litigation, there are time limits for challenging the award. I think under the Arbitration Act that it's 28 days of the date of the award. And as I said, you can actually only appeal under certain grounds. So, for example, you could argue that the award is incomplete and it's not addressed one of the issues in dispute, that it contains a mistake as to the law, or that there's been some form of maybe irregularity affecting the tribunal, which has impacted on the award. I should just caveat what I'm saying is that that is an answer in relation to an arbitration under the Arbitration Act, but each specific arbitral body, which I mentioned, has different sets of rules, so you should always check these in terms of the appeal process.
Okay. Hopefully that's addressed those questions. I think we've run out of time now, so we hope that today's webinar has been helpful in identifying those issues which trustees need to be particularly mindful of when a dispute arises. As I said, we will follow up on those questions which we've not had a chance to answer by email, and we will also send out slides from this presentation together with a recording of the webinar itself, should you wish to share it with your colleagues. I should also say that under the resource list on your screen, you'll find a link to our team's recent newsletter, which we produce on a bi-monthly basis. So please feel free to register to receive those newsletters by email in the future. So thank you very much.